So this will finish up our chapter on economic substantive due process. And as you can see, the fall of the Lochner doctrine, and not only the fall of the Lochner doctrine, but basically where we get that the court just pretty much says, we aren't touching anything here. But then you kind of get a little bit of a comeback in some other areas. So again, this will finish off the chapter. We have 4 cases today. They won't last. Some of them are, I'm going to get through the last 2 probably a little bit more quickly. So the New Deal in the Supreme Court. So that's a picture of me in 2014 there at the Franklin Delano Roosevelt Presidential Library in Hyde Park. So the governor of our state, Franklin Roosevelt, wins the Democratic nomination in 1932 and is elected in a landslide over Herbert Hoover. You know, it was big. Hoover only won just a few states. So the one thing is the country was in a bad place. The Depression had been going on since 1929. And remember, the president doesn't even take over at this time until March. So it's March the 4th, not January the 20th. So you'd had a Great Depression that had been going on for a while. And one thing is about Herbert Hoover, he was a tremendous humanitarian. After World War I, because of his efforts, millions of people in Belgium probably were saved from starvation. But he was also a believer in this laissez-faire social Darwinism that really influenced a lot of national policy during the 1920s. So Hoover had been elected in 1928. In fact, he was so popular after World War I because of his aid in Belgium. You know, both parties actually wanted him to run in 1920. People really didn't know which side he was on. So he took the job of Secretary of Commerce. But one of the things is we found out that Herbert Hoover was definitely a conservative. So even when you have this grave national emergency of the Great Depression, Hoover, because he was tied so much to saying basically the federal government shouldn't do this. You know, we should leave it up to private charities and churches and things to help out with the relief. Now, the problem is when you have unemployment between 25-30% unemployment across the country, you know, when you have farms being foreclosed on, people's homes being foreclosed on, you know, the Dust Bowl in the Great Plains. It's one of those things where, you know, a big event calls for some big measures. So, you know, FDR, you know, he gets elected, you know, he gives in his inaugural speech, the only thing we have to fear is fear itself. Also talks about a chicken in every pot. Or actually, I think it was somebody else. But doesn't everybody want a chicken in their pot? Maybe if you don't like chicken or if you're a vegan, maybe not. But so he had a very ambitious legislative agenda. You know, Democrats came in with a massive majority. And in fact, in 1934, Democrats actually gained seats in the House and Senate, which is something that is kind of unheard of. Basically, that's the only time that a party gained seats in the House and the Senate, where up until 2002 with George W. Bush after 9/11. So one of the things that this did is that this was a radical and something that we live with today. And that is, at that point, the most intervention in the federal government in the national economy. So we still live with a lot of the programs of the Roosevelt administration and the New Deal. Things that probably we take for granted, like the Social Security system, unemployment insurance, a minimum wage, laws that basically require that unions are recognized. So FDR gets a lot of stuff passed. Then he helps win World War II. So, you know, one of those things is that I don't know if you've ever been to Mount Rushmore in South Dakota, but, you know, there's always talk, should you put another president on it? Well, you actually couldn't. I don't think it's actually possible. But, you know, if you're going to add another person, it's probably FDR. You know, he you have other presidents that have faced crises before, but literally the destruction of the economy and the potential of losing to fascist dictatorships around the world. He did pretty good there. So a lot of these things were to try to rescue the economy. Now, the thing is, was it the magic bullet that took unemployment to 5%? No. Did a lot of these programs help to alleviate the depression? Yes. Did at a certain point in his second term, when FDR pulled back on some of the government spending, did the country kind of revert back a little bit? It was the Roosevelt recession in 1938? Yes. But these programs were wildly popular with the public. Remember, FDR won an enormous victory in 1932. Republicans, they're running Alf Landon in 1936. We'll see on the next slide what happens there. I think, I hope I'm not ruining it for you, but he does get reelected and reelected and reelected. But despite the fact that you had overwhelmingly public support. So remember, gaining seats in a midterm election is very unusual. Very unusual. And it wasn't just a small gain either. So, the country really was like, yeah, FDR, we like your stuff. We want people to go in there to help vote for them, the stuff. But the Four Horsemen, often joined by Justice Owen Roberts, struck down a lot of pieces of New Deal legislation. FDR was not pleased. He was not pleased at all. And during the 1936-37 term, so remember, a term starts the first Monday of October, and it's going to go to June, July of the next year. Well, you just think about that. It happens 1936 in October. What happens a month later? An election for president. So there was actually one poll polling was kind of new back then, where they only called people on telephones. People back then, poor people tended to be more democratic, was one of the things that came out of the New Deal coalition, while wealthier people tended to be more Republican. So, who's probably going to have a telephone back then? So this was the most massive electoral victory in history. So FDR won the biggest share of the electoral vote of any president in a contested election. Only George Washington and James Monroe, who were unopposed, got away through this. So he won all but two states. So two states voted against him, Maine and Vermont. So Alf Landon, the governor of Kansas, only got 8 electoral votes. So Ronald Reagan actually got more total electoral votes, but one of the reasons is that there were 50 states by then. So the number of electoral votes was higher total, but as a percentage, FDR gets the total. So at the time of a contested election, it was the highest percentage of the popular vote ever. So, just think about this. You've only had 4 times in American history in a contested election where a president got over 60% of the popular vote. This is one of them. And the only president that actually got a higher percentage of the popular vote was LBJ in 1964 by a smaller amount. But, you look on that map, there's a lot of blue. Democrats also won some of the biggest majorities in the history of our Congress. So I think that probably the only ones that would probably rival this would be after, I think, the 1866 elections. Or 1860, so kind of in what would have been Lincoln's second term and the Johnson term. Where one of the things is that Republicans had such a big majority because literally large parts of the country were not sending anybody to Congress, aka the South. So I want you to just think, this does not include some independent members here. The Democratic majority was 334 to 88. The Senate, 74 to 17. Just to give you an example, after the 2020 election and after the 2022 elections, there you can see that I'm not giving you some stale lectures here. both the Democratic majority after 2020 and the Republican majority after 2022 was 222 to 213. Yeah. After, the massive Watergate election and after LBJ's landslide in 1964, Democrats had about 290 seats or so. Think about that. 334. Republicans had less than 100 seats. That is kind of unheard of. So remember, the House of Representatives has been fixed at 435 since about the 1920s, I think. So before that, they would just add more seats, and they kind of decided, maybe we need to quit doing that. Here's just to give you an example. I'll tell you something that maybe most people don't know, is that in the Senate chamber, the Democrats sit on one side and the Republicans sit on the other side. They actually have desks. In the House, it's more kind of like theater seating. And by the way, the back of those seats are actually bulletproof. Bet you all didn't know that. I used to give tours of the Capitol, and I worked over on the House side, so that's generally where I took people. In the Senate, even if they, I think a lot of people think, oh, well, there's 100 senators, so 50 people sit on one side, 50 people sit on the other side. Well, that's actually not how it works. It's that if there's more Democrats or more Republicans than 50, they actually just squeeze more seats in. So, the last time one party had 60 seats, which is the number today needed to overcome a filibuster, was Democrats in about 2009 after Arlen Specter switched parties. So what happened is that the Republican desks were just kind of spaced out a little bit more, and the Democratic desks were squeezed in more. This was kind of the first time in modern political history where the Senate actually meets, because remember, they used to meet in a smaller area, kind of in the 20th century, where there were so many Democratic senators, they actually took up some rows in the back of where the Republicans sat, because there were just so few Republicans. But remember this, and this is something that I had mentioned in previous lectures. The parties were not quite what they are today. So, you see a lot of that blue there in the South. That was Democratic blue. And a number of those states, FDR got over 90 or 95% of the vote. But, here's the but. A lot of those Democrats were quite conservative. So, more conservative than a lot of the Republicans. And a lot of the Democrats from some of those more sparsely populated Western states were also fairly conservative. So this did not mean that you had 334 liberal Democrats and 74 liberal Democrats in the Senate that were always going to back FDR and everything. In fact, FDR's vice president, John Nance Garner, who was actually one of the driving forces in opposition to what we know as the court packing plan, was quite conservative himself. He wanted to run for president himself. FDR ran again, so it didn't work out for him. So FDR thought, hey, I have won two of the biggest electoral and popular vote landslides in American history. So, he's probably thinking, yeah, we've had some president, we've had a president that maybe won big one year, maybe this, but I did it twice. I have the biggest majorities in the Congress since Reconstruction. Also, another thing is, FDR, despite the fact that people didn't serve on the Supreme Court as long as they do now, there were no retirements during his first term. So, that sometimes happens. Jimmy Carter only had one term and there were no retirements. He's one of only three presidents that didn't have an appointment. The other two presidents that didn't, Taylor and Harrison, died in office. So, George W. Bush in his first term did not have any appointments to the Supreme Court. But then you have some presidents that have a lot. Richard Nixon had 4. Donald Trump had 3. Though the thing is, I think you have to say the 3 there. He had 3, but, one of them was held open. One of them was done right at the end, but he still got 3. You can question the process, but, and you can put an asterisk on it. But there are still 3 people sitting on the Supreme Court today that were appointed by Donald J. Trump. So let's take a look here at a clip from FDR's speech on the issue from the University of Virginia. Collected some clips.
They are described in detail certain economic problems which everyone admits now face the nation. For the many messages which have come to me after that speech, and which it is physically impossible to answer individually, I take this means of saying thank you. Tonight, sitting at my desk in the White House, I make my first radio report to the people in my second term of office. I'm reminded of that evening in March 4 years ago when I made my first radio report to you. We were then in the midst of the great banking crisis. Soon after, with the authority of the Congress, we asked the nation to turn over all of its privately held gold, dollar for dollar, to the government of the United States. Today's recovery proves how right that policy was. But when almost 2 years later, it came before the Supreme Court, its constitutionality was upheld only by a 5-4 vote. The change of one vote would have thrown all the affairs of this great nation back into hopeless chaos. What is my proposal? It is simply this. Whenever a judge or justice of any federal court has reached the age of 70 and does not avail himself of the opportunity to retire on a pension, a new member shall be appointed by the president then in office with the approval, as required by the Constitution, of the Senate of the United States. That plan has 2 chief purposes. By bringing into the judicial system a steady and continuing stream of new and younger blood, I hope first to make the administration of all federal justice from the bottom to the top speedier and therefore less costly. Secondly, to bring to the decision of social and economic problems younger men who have had personal experience and contact with modern facts and circumstances under which average men have to live and work. This plan will save our national Constitution from hardening of the judicial artery. Those opposing this plan have sought to arouse prejudice and fear by crying that I am seeking to pack the Supreme Court and that a baneful precedent will be established. What do they mean by the words, packing the Supreme Court? Let me answer this question with a bluntness that will end all honest misunderstanding of my purposes. If by that phrase, packing the court, it is charged that I wish to place on the bench spineless puppets who would disregard the law and would decide specific cases as I wished them to be decided, I make this answer, that no president fit for his office would appoint, and no Senate of honorable men fit for their office would confirm that kind of appointees to the Supreme Court. But if by that phrase the charge is made that I would appoint and the Senate would confirm justices worthy to sit beside present members of the court who understand modern conditions, that I will appoint justices who will not undertake to override the judgment of the Congress on legislative policy, that I will appoint justices who will act as justices and not as legislators, if the appointment of such justices can be called packing the court, then I say that I, and with me the vast majority of the American people, favor doing just that thing now. During the last half century, the balance of power between the three great branches of the federal government has been tipped out of balance by the courts in direct contradiction of the high purposes of the framers of the Constitution. It is my purpose to restore that balance. You who know me will accept my solemn assurance that in a world in which democracy is under attack, I seek to make American democracy succeed. You and I will do our part.
Ladies and gentlemen, you have heard the President of the United States speaking on his proposal for reorganization of...
So just to let you know this, is that this was not only just for the Supreme Court. This was also all the other federal courts. So one thing that you have to remember, and I probably asked you this, I don't know if I asked you this on the quiz or not, but one thing is this. The number of members of the Supreme Court is not set in the Constitution. It's just stayed at 9 for a long time. Now, one of the problems is that if you start changing the number, what stops somebody later from changing it again? At what point do you have 59 members of the Supreme Court? So one of the bigger features here was that the president could appoint up to 6 additional justices for each justice that was not retired above the age of 70. So I think some of it was kind of, why don't you retire? So, essentially what this is able to do is that you just think about this. Well, FDR had, the 4 horsemen plus Roberts, and then sometimes the chief, sometimes maybe a 6th member that would vote against him as well. And remember, a few of these decisions were actually 8-1 or 9-0. But let's say it's 6 members. Well, he's going to have 9. So the goal was basically what... So notice also how Roosevelt was putting this. So, at the time, we are looking around the world and seeing Germany, Italy having fascist and Nazi regimes. We're seeing the expansionism of Japan, and where it looks like democracy is kind of going downhill. And he's making the point, of course, that as you see there, the balance between the 3 branches of government is out of whack. That basically you have the Supreme Court that's unelected and basically has all these old farts on it that basically are vetoing all of this stuff that the elected Congress is passing and the elected president is implementing. Now, Democrats actually opposed this plan, including his own vice president, John Nance Garner, Democrat of Texas, often known as Cactus Jack. So basically, the one thing is that it kind of gave an ultimatum. Like, if you don't retire, the president gets to appoint somebody that's basically going to cancel out your vote to the folks there. Now, I think that this does... I think that one of the things that this does, of course, is that it gave you kind of a thing. Is FDR just trying to seize power? That he controls one branch of government as the president. Congress is going along with him on a lot of his stuff, and he's stopping the Supreme Court. You see this cartoon here that basically the only thing stopping us from dictatorship is the Supreme Court. I think that's wrong. I think that's a wrong-headed way of looking at it, because actually Republicans pick up a lot of seats in 1938, and a lot of them they actually join with a lot of the Southern and Western conservatives in the Democratic Party to stymie most of his legislation during his second term. You just because you have that, I think one of the things that FDR is trying to point out is the people want these things, and really what the Supreme Court is doing, they're basing this less off of actually the Constitution And what they're basing it on is their own views that they do not think some things should happen. So public opinion was kind of divided. So remember, FDR, it seemed like during his first term, couldn't get anything wrong. During his second term, it seemed like he couldn't get a lot of things right domestically. Turns out later in the first term, that things start getting to FDR thinking, yeah, something's going to happen over in Europe pretty soon. Maybe we need to be thinking about that. So FDR suffered a major setback when the majority leader, Albert Robertson, a strong supporter of him. So remember, not all of the Southern members were kind of, these harsh Dixiecrat conservatives. They were pretty much all against civil rights. But some of them were quite liberal on other things. But the majority leader, Albert Robertson, who was the person that was going to push it through the Senate, which the Senate was going to be the problem because you had, at that time, to get over a filibuster, if somebody's going to if one side wanted to filibuster something, it was a 2/3 vote. He died suddenly. So let's take a look here about a clip here from Supreme Court, documentary on PBS about reshaping the court.
To save the New Deal, Roosevelt proposed a radical piece of legislation, a bill to give him the power to appoint additional justices to the Supreme Court and outnumber his opponents. On Capitol Hill, critics argued that Roosevelt's bill challenged the Constitution itself.
I shall not be a party to breaking down the checks and balances of the Constitution.
A packed jury, a packed court, and a stuffed ballot box are all on the same moral plane. This is more power than a good man should want, or a bad man should have.
This is a non-partisan battle to preserve an independent Supreme Court.
Determined to win votes for his court plan, Roosevelt was now in the congressional fight of his life. He dangled promises of federal projects, hinted at judicial appointments, threatened to withdraw patronage. At a picnic for Democratic congressmen, he turned on all his charm. This time, it didn't work. On July 20th, he asked his vice president, Jack Garner, what his chances were with Congress. "Do you want it with the bark on or off, Captain?" Garner replied. "The rough way." "All right, you're beat. You haven't got the votes."
And the price that he paid was very high. It was a loss of confidence on the part of the country. It was a recognition by his opponents in politics that they could beat him. It was a recognition on his part that he had lost some measure of power.
So I just think you have to think about it this way too. And I'm not saying that I'm supporting what FDR did or opposing it. But if you have the Supreme Court essentially acting as a political actor, and you don't have the ability to get rid of any of these people because of lifetime tenure, and I think that's a whole other issue, what do you do? I mean, what if you have just these recalcitrant people on there that are just stuck around for decades, and there's just no other way to get around them? So one thing is that I would just tell you a few things here. So whenever FDR was pushing through this plan, there was actually a special election in Texas, in the then 10th Congressional District, including Austin and surrounding counties in the Hill Country in Texas. And it was, whoever got the most votes won. There's no runoff on the Democratic primary, which essentially was the election. And there was a young former congressional staffer, or actually he was a current congressional staffer, I think, that ran on supporting the court packing plan. He won. His name was Lyndon Baines Johnson, who actually didn't try to do some court packing, but he did manipulate some stuff on the Supreme Court with getting some people to retire and putting some people on that he wanted. So the swing vote on the court had actually always been Justice Owen Roberts. So he's no relation to John Roberts. There's his picture. He actually, whenever later, he was actually pretty well respected around in Washington. And in fact, whenever there was a commission set up to try to see what had happened, what had gone wrong in Pearl Harbor, he was actually on the commission. I can't remember if he was the chairman or not. Now, Roberts had been the decisive vote to overturn some New Deal laws and some 5-4 votes. He'd also upheld a few and some 5-4 votes. So basically those four horsemen, more or less, it was if there's any type of stuff that looks liberal or progressive, it's going down. So after West Coast Hotel versus Parrish was argued, he actually voted to overturn Adkins. So remember, Adkins was kind of Lochner on steroids, if you will. So because of an illness of the Chief Justice Stone, it was a 4-4 tie. So actually, he becomes later Chief Justice. Chief Justice Charles Evans Hughes, kind of a moderate Republican, waited for Stone to return, and then the decision was 5-4 to overturn. So Roberts made the decision to side with FDR before the court packing plan. So some people argue it's unfair to say that the court packing plan for his change of heart. But one of the things was the fact that Roosevelt was reelected so big? I don't know. I mean, I think it's one of those things that how do you quite say what the deal is, or are some people going to dispute that? But let's take a look at the case here, and then I'll talk about kind of the aftermath. So the person had been a maid at a hotel, and she was let go. She asked for back pay equal to what she would have received had the company complied with the minimum wage law of the state of Washington. And that actually is the picture of the person there. So she refused to settle, and won at the Supreme Court level. The hotel lost and appealed. So did the minimum wage law violate the Liberty contract under the Fifth Amendment as applied by the 14th Amendment? So here's the thing that you have to look at, is that Adkins basically was a similar regulation. It's basically the same. Tipaldo, kind of the same. Basically, if you just kind of look at these cases, they control. And, basically they're the same. It's one of those, situations where, you just look at something and you're kind of like, is this kind of the exact same thing that we saw a few years ago, or maybe many years ago, or maybe not even that many years ago? So for Parrish to uphold the law, she wants her money. Ernest and Elsie Parrish. So they're saying they're making kind of a judicial deference argument. So the legislature decides on what the public welfare is and what should be the minimum wage. Why should the courts come in and say, no, you can't do it? So Adkins doesn't apply. So they're trying to get around Adkins, saying, they also say basically that Adkins should be overturned, so should Lochner. Doesn't apply because the state's police powers are broader than at the federal level, and that there should be a presumption of constitutionality. That it's kind of the highest level of action of the court when they overturn a law that is approved by a legislature, by a state legislature, and then signed by a governor or overridden. That you should really be kind of, if you will, very hesitant to do that. It's 5-4 court. So you see there is the Wicked Witch of the West, if you remember from The Wizard of Oz. Ding dong, the witch is dead. So Adkins is explicitly overruled in this case by Chief Justice Hughes. The vote that he got that gave him this to be a 5-4 decision was Justice Roberts, who had switched his vote from a lot of the previous cases where he had went. So it was one of the so-called White Monday cases. There were a number of cases that came out, I think there were 3 cases that came out on the same day, that upheld the New Deal legislation and progressive legislation around the country. So liberty is subject to regulation for health, safety, morals, and the general welfare. So listen to this. There is not an absolute freedom of contract. This basically is taking Adkins, it's taking Lochner, and basically, finding those decisions, wadding them up, shredding them, sticking them in an incinerator, maybe whatever you're going to do to eliminate something. So the statute does not compel anybody to do anything. Just you can't pay wages below a certain amount. To ensure a minimum standard of living, employer and employees were not completely free in negotiations. So the Great Depression helps justify the law. Now that's one thing that, when you put that in there, does this mean that's a little bit more temporary? Now, they continue with Mueller on the role of women, which is not a good thing. But one thing that we're going to see later in the semester is this. Different tests to see whether a law is constitutional. So what test you adopt generally is whether something's going to be found to be constitutional or not. Rational basis, that's the most deferential of the government. That is the most deferential. So they overrule Adkins. So the argument that the legislation in question constitutes an arbitrary discrimination because it does not extend to men, so kind of the Mueller argument here, is unavailing. So basically kind of quoting that. So, the one thing is, they say the bare cost of living must be met. You just think about that. Kind of the way some of these minimum wage laws are written is not necessarily saying, okay, X, you have to pay these. This is the wage that the legislature is saying X number of dollars. Often, what was happening is that they were setting up wage boards that would say, okay, this is what you need to pay because we're wanting these people to have a living wage. Excuse me, I need to get some water here, so I'm a little bit hoarse. So the dissent here by Justice Sutherland, joined by his horseman colleagues, said the court failed to follow precedent. He's right. They did. But he also argues against judicial deference. So the judicial function is that of interpretation. It does not include the power of amendment under the guise of interpretation. To miss the point of the difference between the two is to miss all the phrase that the supreme law of the land stands for and to convert what was intended as inescapable and enduring mandates to as mere moral functions. If the Constitution, intelligently and reasonably construed in the light of these principles, stands in the way of desirable legislation, the blame must rest upon that instrument and not upon the court for enforcing its terms. The remedy to that situation is an amendment to the Constitution. So he's really rejecting living Constitution doctrine, saying that it doesn't flow with the ebb and flow. But I think one of the things that it kind of misses, that if you go back to some of the cases, if you go back to the slaughterhouse cases, well, hell, that didn't go the same way. It didn't. So White Monday. So 2 other cases go with FDR. So just think about this date here. So the president this time was going to take office on January the 20th. Well, let's say all these cases would have came out a different way. Because remember, another one of these things was upholding the Wagner Act and the Social Security Act. So, I mean, just think about that. If you would have overturned the law that basically allowed unions and created Social Security, what do you think the public opinion of that would have been? So remember, early on, public opinion was kind of like, I don't know about this. I think a lot of people at the time were thinking, boy, what the Supreme Court is doing is wrong. But do we want to change? But do we want to increase the number of justices? So I think that when you say it was mixed, it was not only that the people were divided. I think a lot of people were kind of thinking, I understand the arguments of the one side. I understand the arguments of the other. Well, I mean, that's one of those things where it's not like, hard 50% yes, hard 50% no. There was a lot of people that were kind of, maybe I lean against it, maybe I lean for it. So if they would have overturned those, I think FDR could have really pushed it. So I think one of the big arguments that after White Monday, that for a lot of Democrats in Congress and for the public in general, okay, the court is no longer kind of out of step. It's no longer really out of step with this. So they've maybe even if there was pressure or not. And remember, until a case is released, I mean, it can still change. But you really have to think, maybe that since there was maybe no need for it anymore. So FDR was pushing this legislation because of an extremely activist Supreme Court overturning a lot of laws of the people. Now they weren't doing it anymore. It's one of those things where maybe you just don't need it anymore. So a few things happened. So May 18th, 1937. So here's kind of the interesting thing, is that Justice Vandiver probably would have retired a lot sooner, but Congress, as a result of the Great Depression, had made it where judicial pensions were about half as much as they were before. He was not a wealthy man. In fact, he was actually from my home state of Indiana, I found. From Marion, Indiana, not from where I'm from. I think you all can tell I'm basically from Kentucky. But Marion, Indiana, also the home of, I think, where James Dean is from. Was from. Or, I guess he still is. I mean, he just isn't with us. Neither is Justice Vandiver. So basically, Congress passes a bill to pay retired justices their salary as a pension. So one thing about Justice Vandiver is that he really didn't like New Deal legislation, and he stuck around, one of the reasons for that, but he also needed his pension. He basically needed his salary. So he's replaced by a very liberal senator, Hugo Black of Alabama. Somebody that, very interesting justice that we'll see. So then the thing is, that means that if FDR has the 4 votes from some of the other justices, so if he has the votes of justices, some of them are going to retire, but if he has the votes of Justice Brandeis, Cardozo, Hughes, and Stone, he doesn't need Roberts anymore. Then the thing is, things really start to coming up Millhouse for FDR. Justice Sutherland retires the next year. Justice Butler dies the year after that. And Justice McReynolds retires 2 years later. So you have a situation where you kind of have an FDR court. I mean, that's one of the things is if you're a president for about a little over 12 years, you're going to get a lot of justice on the Supreme Court, especially when a lot of them were a lot of old farts. So this, along with some other things that you would learn in Political Science 303 if you have taken it in the past or you're taking it in the future. I teach it, and so does Professor Hinkle. We both teach it very well. Check the schedule of classes if you want to take it, because it's out there. I mean, sometimes we teach it each semester. Sometimes I teach during the summer. Take a look. If I teach it in the summer, it will be online. So basically what happens is that his bill passes, but pretty much everything in it that was anything controversial was stripped out. This also meant, along with a lot of other things, the ability of Congress to pass something under the Commerce Clause, the tax and spend powers, delegation of authority, basically what the court says after this. And you start to get some limits when you get some of, like, the Rehnquist court and some things. But they're basically saying, if Congress passes it, it's okay. We're not going to bother you. AKA judicial deference. Basically saying that, we're not elected. We ought to leave it up to the elected branches. So the reason that we have Williamson versus Lee Optical Company, and I'm going to go through this pretty quick, by the way, is basically just to show you how far the court goes in basically rejecting Lochner. So Oklahoma had a law that made it illegal for somebody than an ophthalmologist and an optometrist to fit, adjust, or apply lenses, frames, anything else to the face. So as somebody that's worn glasses or contacts since the 4th grade, and whose vision, if I take them out, is pretty darn bad, one thing is if you wear contacts and you have glasses as your backup, it's not a big of an issue. But, if glasses are your primary mode of, sight, sometimes you have a lens fall out, it's not quite right on your head. When something's literally going to sit on your head, sit on your face for large periods of time during the day, you want it to be comfortable. So one of the things is that so usually whenever you have that, you don't really see your eye doctor. It's usually somebody that works there, that kind of, maybe it's something where they just tighten a screw or they move something around or something. So the thought was that it violated the right to perform a craft. So did this violate the Due Process Clause of the 14th Amendment? So Oklahoma said it's a matter of public health. Provide the citizens with the best vision care possible. Defer to the Oklahoma General Assembly is the public policy, and there should be a presumption of constitutionality. So that's kind of what was said by the critics of Lochner and Atkins all along. Why are we coming in here like a super legislature and determining what laws are good and what laws are bad? So Lee Optical says it's denying the right of opticians to perform their jobs, denies their due process laws, and it's not a public health measure. It's a unanimous decision. It is a unanimous decision. It's 8-0. Justice Harlan was not participating. I don't know why. I do know that he had poor vision later in his life, where he literally couldn't see, and some of his clerks had to read opinions and read stuff to him. But basically, Justice Douglas said it's a wasteful requirement. But they applied rational basis. So rational basis means as long as something is rationally related to a legitimate government objective, it's okay. So we are going to defer to the judgment of the legislature. It's not up to the courts to determine what's useful or needless or wasteful. So I think what Justice Douglas would say, if you think something's bad, go to the Oklahoma legislature and get them to repeal it. So, boy, here's the quote. The day is gone when the court uses the Due Process Clause of the 14th Amendment to strike down state laws regulatory of business and industrial conditions because they may be unwise, improvident, or out of harmony with a particular school of thought. We emphasize what Chief Justice Waite said in Munn v. Illinois. For protection against abuses by legislatures, the people must resort to the polls and not the courts. Boy, if that's not the most straightforward saying that our hands are off. Our hands are off here. We are not going to. We're not going to go back. So we have 2 cases left, and I'm just going to tell you that they're kind of they're there, but I'm not going to go through them as big, because this is kind of where the court. So I think that both of these cases are probably pretty vulnerable, especially the Massey case under this new conservative majority. I mean, this BMW case versus Gore, and this is no relation to Al Gore, the former vice president. So Gore buys a BMW and finds that it was repainted. So he says he was wrong. He sued BMW and he asked for compensatory and private damages, punitive damages. So they gave him $4,000 in compensatory damages and $4 million in punitive damages. So, I mean, this is one of those things where I'm like, okay, I can understand you give him the money because it was repainted and some stuff he thought it wasn't. $4 million? It's kind of like, why? So the Alabama Supreme Court reduced it to $2 million. So BMW wanted the punitive damage set aside as excessive. So does the 14th Amendment Due Process Clause prevent excessive punitive damages from being awarded? I think it's kind of an interesting argument. So BMW says Alabama can't punish because it happened out of state. Different argument. The war was too high. It was outside of the range of actual damages, so far beyond it was needed for deterrence. So Gore said, the conduct was really bad. This is one of those things where I just sit back and go, they repainted it. I mean, it's not like they did something where you got butchered up in an accident. Hell, give me a repainted BMW and I'll take $1 million for not knowing it. Hell, I'd take $10,000. I'm not that easy to please. So the award was to punish and deter future conduct, which is one of the things about punitive damages that we have in civil court. Also, the thing is, punitive damages can, if you're getting them, you can really like them. I mean, it's kind of like, oh, I bought a car and they repainted it. I get $4 million. I get $2 million. I mean, it always reminds me, when people ask for such, enormous sums and things, it always reminds me of that time, on Oprah Winfrey show where, she's like, you get a car, you get a car, you get a car. But it was to deter bad behavior on a nationwide level. So this is one of the things that's kind of more out there. Yeah. Drink of water here. So it's an unusual lineup of justices. So Justice Stevens writes the opinion, but it's Breyer, Kennedy, O'Connor, Souter, and Stevens. So a little bit more, the center of the court, while the dissenting justices are Ginsburg, Rehnquist, Scalia, and Thomas. So kind of the hard conservatives plus Ginsburg. So punitive damages can be used as legitimate state interest, so states have a lot of leeway, even if it has a nationwide effect. But one does have to look at whether it violates the state's ability to regulate. So only gross excessive awards can violate due process, and this does. So the court kind of creates a 3-part test. The degree of the responsibility of the defendant, the ratio of punitive damages to compensatory damages, comparison of punitive damages to similar criminal or civil penalties. So, the one thing is that it's kind of interesting because most of the more center-left justices side here more with corporations because versus kind of how if you will, if you see things politically more with jury awards and things. So Breyer has a middle ground concurring opinion joined by Souter and O'Connor, saying severe disproportionality. I think it's too high. So Scalia says the court should have stayed out. There's no constitutional implications here. Leave this up to state judges and juries. Leave this up to states if a state wants to pass a law that says, you can't have, we're going to limit awards here and do some things. So Ginsburg and Rehnquist. So this is federalism, is what they're arguing. Leave it up to states. This is their territory. So if you ever seen the State Farm commercial, there's I can't remember his name. It was Jake from State Farm in his khakis. So the court rejected a mathematical formula again, but seemed to think that 10-to-1 punitive versus compensatory would be good. So our last case here, so I told you we're going to go through some of these pretty quick here at the end. So at the time, West Virginia had a partisanly elected state Supreme Court, 5 members. That's the state Supreme Court there in West Virginia. Have I been there? No. Have I been to Charleston? I've been to Charleston, but never been to the Supreme Court chamber. So Don Blankenship was a coal baron and not only a big Republican donor, the biggest Republican donor in the state. So he's also somebody that eventually went to prison, federal prison, because of negligence that was found to be pretty bad, if you will. Based on, if you will, really bad conduct. So one thing is that I have kept this case in here because I think it's very interesting, if you will. So Caperton versus A.T. Massey Coal Company. So here's one of the kind of things that we have in the era of independent expenditures. And this was before West Virginia became such a solidly Republican state. So independent expenditures are a way around contribution limits. So he spent $3 million to elect Republican Brent Benjamin. So this was the majority of the entire spending of the campaign. So when the case reaches the West Virginia Supreme Court, Benjamin refuses to recuse, and he was the decisive vote. It was 3-2. The other justices were challenged to recuse, but not Benjamin. So did this violate the 14th Amendment? So recusal requires not only the actual bias, but probability of bias. So further, Caperton here. No relation to the former, I think it's not the former governor who was actually Governor Caperton. So just campaign requirements don't require recusal, but this was special. This was literally almost all the money. So this was how Benjamin got his seat. So him setting on this case does not give Caperton a fair hearing. So for Blankenship, they said that there's no precedent here. Talking about the probability of bias. So this is for Don Blankenship. I'm going to show you an ad from here. So recusal is only required when there's monetary outcome by the judge that they would face whether they won or lost, so violating due process. So it doesn't rise to the probability of bias either. So, the thing is, justices hear cases all the time involving politics, friendships, and other views. And also remember that when you have elected Supreme Court members or elected judges, who the heck do you think that they get money from? Now, Don Blankenship did go to jail at the federal level because of one of his mines. He also ran for the Senate in 2018. I think he actually ran for president on the Constitution Party ticket. But I'm going to show you here one of the most bizarre campaign ads I've ever seen.
Hi, I'm Don Blankenship, candidate for U.S. Senate, and I approve this message. Swamp Captain Mitch McConnell has created millions of jobs for China people. While doing so, Mitch has gotten rich. In fact, his China family has given him tens of millions of dollars. Mitch's swamp people are now running false negative ads against me. They are also childishly calling me despicable and mentally ill. The war to drain the swamp and create jobs for West Virginia people has begun. I will beat Joe Manchin and ditch Cocaine Mitch for the sake of the kids.
Well, he did not win the Republican nomination in 2018. Patrick Morrissey, he's currently still the state attorney general, ran, and Joe Manchin won. Would have been interesting to see a Blankenship versus Manchin campaign, but we didn't get it. So it was a 5-4 decision. I think that this is one of the cases that that with the new conservative majority is pretty darn vulnerable. So, you just think about it during kind of that era where Kennedy was the swing vote. and cases were 5-4, it's kind of like, okay, you've not only had Kennedy replaced, but you've also had Ginsburg replaced. So, judicial recusal is part of fair process. So I think that this is one of those things where Kennedy and the majority is saying, you know what, normally we're not going to say a campaign contribution is bad, is going to require recusal, but boy, this is going beyond the pale. So it must be when there's a direct personal or substantial pecuniary interest in the case, but personal bias alone is not a constitutional issue. So in Toomey versus Ohio, when the judge got his salary from fines, but part of the money if the defendant was convicted. So recusal may be required in contempt proceedings. So when does it go too far? Under realistic appraisal of psychological tendencies and human weaknesses. So there's no evidence of quid pro quo, but I think the problem here is that Benjamin should have recused himself, amounting to a denial of due process. So this is basically where almost all the money that went to support his campaign was from one person, who is basically kind of thinking almost like in a Pelican Brief type situation. Pelican Brief was one where where folks actually had some justices killed. It's not what Don Blankenship was doing here, but it was literally, I'm basically spending all the money to elect somebody that's going to vote in my favor. So Chief Justice Roberts, joined by the other conservatives who make a slippery slope argument, how much is too much? Scalia says, there's not a constitutional issue. So there was a Florida case upholds a judicial ban on personally soliciting campaign funds. Kind of interesting, I think. So next time, what we will do is that we'll move on to the takings clause of the Fifth Amendment. There are 2 lectures. They're of different lengths, I'll tell you that. One is longer and one's shorter. But that's where we're going to end today. So hope you all are doing well. And if you have any questions, please let me know. Bye-bye.